to our education update. I'm Beth Alberger, the Safe Recruitment Manager and Trainer at EPM. I'll be providing your school and trust with the key updates and considerations surrounding safer recruitment. Since our last update, we've seen some significant changes to legislation and keeping children safe in education following our departure from the EU. In particular, during this session, I'll be discussing the changes to the DBS Filtering Rules that came into force on the 28th of November 2020. I'll be looking at the action required to update your application forms to become compliant with these changes, along with the criminal self-declaration forms. I'll also go through the changes to the statutory guidance document Keeping Children Safe in Education now that we've left the EU, and the implications for some changes to your SCR that you may wish to consider. Remember, to accompany this update, we've also produced an action checklist. Please download a copy of this checklist, as it's intended to be a helpful guide for senior employees to allow you to easily identify the actions and key priorities that you should consider to help you prepare for the summer term. On the 28th of November 2020, the DBS filtering rules for standard and enhanced DBS checks changed. These changes were a result of the Supreme Court judgment, which identified that some elements of the existing filtering rules were disproportionate. Legislation has been changed, and that means from the 28th of November 2020, DBS certificates will disclose criminal records according to the new legislation. This means that the Disclosure and Barring Service will no longer disclose youth reprimands, youth warnings, or youth cautions. They will also no longer automatically disclose all convictions where an individual has more than one conviction. Instead, each individual conviction will be assessed against the appropriate rules. The new filtering rules have been applied to all certificates processed from the 28th of November onwards. Any certificates produced prior to this date will be in line with the previous filtering rules. Filtering is the term used to describe the process that identifies which criminal records will be disclosed on a standard or enhanced DBS certificate. Certain old or minor offences may not be disclosed on DBS certificates. These are known as protected offences. There is a list of offences that will always be disclosed on standard or enhanced DBS certificates, unless they relate to a youth caution. These are known as specified offences and are usually of a serious or violent or sexual nature, or are relevant to safeguarding children and vulnerable adults. All convictions resulting in a custodial sentence, whether or not suspended, will always be disclosed. Youth cautions, warnings and reprimands will not be disclosed automatically on a standard or enhanced DBS certificate. Employers should now consider updating their recruitment processes to reflect the changes in the DBS filtering rules. Within education, the level of DBS check required is enhanced, so application forms relating to positions that are eligible for enhanced DBS checks will need to reflect the filtering rule changes, so that employers can ask the right questions and employees can give the right legally accurate answer. To assist you, EPM have updated our model application forms to ensure you are compliant with the changes in legislation. For those schools and trusts who use their own application forms, you need to ensure you ask the two questions on the screen, either on the application form itself or the self-declaration. When referring to convictions on the application form, we recommend you include the paragraphs: the Amendment to the Rehabilitation of Offenders Act 1974, Exceptions Order 1975, and in brackets 2013 and 2020. This provides that when applying for certain jobs and activities, certain convictions and cautions are considered protected. This means that they do not need to be disclosed to employers, and if they are disclosed, employers cannot take them into account. Guidance about whether a conviction or caution should be disclosed can be found on the Ministry of Justice website. As the filtering rules are now more complicated, we also recommend applicants are directed to impartial legal advice to assist them with their self-declaration. Rest assured, EPM have updated the self-declaration forms in the letter to interview and also the standalone declaration. If you do decide to recruit an applicant who has declared a criminal history, don't forget to complete a risk assessment. This risk assessment should detail the discussion between the individual and the head teacher along with the DBS certificate and be compared against the self-declaration information for consistency. Our model risk assessment also directs you to NACRO, who provide additional questions you may wish to ask to ensure you are able to make an informed recruitment decision. 2.3 of the Handling of DBS Certificate Information states that schools require retention of certificates in order to demonstrate safe recruitment practice for the purpose of safeguarding audits may be legally entitled to retain the certificates. This practice will need to be compliant with the Data Protection Act, Human Rights Act and General Data Protection Regulation, and incorporated within individual organisations' policies on the correct handling of safeguarding of DBS certificate information. So when you are presented with a positive DBS certificate, you are now permitted to retain a copy of the DBS certificate along with a risk assessment detailing how you came to your recruitment decision. This slide looks at the changes that have been made to Part 3 of Keeping Children Safe in Education now that we've left the EU. Paragraph 149 has been updated and now states from the 1st of January 2021, the TRA Teacher Service System will no longer maintain a list of those teachers who have been sanctioned in EEA member states. Advice concerning how information about teachers' past conduct may be obtained can be found in paragraph 172. Paragraph 172 now also indicates for teaching posts the requirement to obtain a letter of professional standing from the professional regulatory authority in the country in which the applicant has worked. Advice about which regulatory professional body applicants should contact is available from the National Recognition Information Centre for the United Kingdom, UK NARIC. However, following the UK's departure from the European Union, the UK NARIC Recognition Agency function has changed from a NARIC, which is the EU-only title, to an ENIC, which is the wider European title for the national recognition agencies, in order to meet the UK's continuing treaty obligations under the Lisbon Recognition Convention. Therefore, from the 1st of March 2021, the UK NARIC agency's title became UK ENIC, operated and managed by Ectis Limited. We recommend any teacher who may need such a letter email the address shown on the slide. They will need to provide the country in which they got their qualification, the country in which they wish to work, and the profession in which they wish to work in. The headings on your single central record may need to be adjusted now that we've left the EU. If you have EEA sanctions and restrictions, you now need to make a note as the requirement ceased as of the 31st of December 2020. It will still remain on your single central record as it was a statutory requirement at the time of recruitment. However, you may now want to add a new column for the letter of professional standing going forward. If you have any questions, please don't hesitate to get in contact with us, or alternatively, you can raise any queries at our next live Q&A session on the 20th of April. Thank you for watching.